slaves and hit those buttons, or I'll send ice.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got that smell, you know, like grape ape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape, it's the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation, with gross castrations, cute citations, by your intimation. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation, with gross castration, in skewed citations, by your intimations. I'm a truth in rotation, you're a cheap imitation. Dog said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bid.
Thank you for joining us at Personality Inventory Mockumentary Productions.
And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Remind everybody, hit that like, share, and subscribe button. There's a PayPal link down below for anybody that wants to share some love. Let me pull that up here on screen for anybody. All is appreciated. All is appreciated. We're going through some tough times right now. They denied our P.I.G.S.C.U.N.T.S filing for the court. They've denied our motions entirely so far. And then today, we find out that Heather Feldkamp steps back into the ring and allows us a transcripts. So let's take a look at that real quick. This is the filings in the case. Starts out here and comes up here. We showed you all the filings previously. And here is the order from Abbott, who denied the application to defer the fees. That was the last denial. So now we're supposed to pay for everything. And of course, Heather Feldkamp comes in and approves the transcript of the recorded court proceeding and a transcriptionist. So we get that. And then Stephanie Rottenberg joined the ring. How this stuff happens, I don't know. I hope I can find out. But Stephanie Rottenberg came in, and first there was a statement of costs, a notice, and it says entered in error. So you see the line striking through everything. That's a strike through. So they struck it from the record. And then other order. So what she did here was, because the plaintiff came in and filed for dismissal, and I believe there's supposed to be 20 days. And so today would have been like the 20th day. So in them dismissing all of my supplemental memorandum of law and review de novo, and then the renewed motion to review, and then the informa pauperis filing, like I said, they're trying to silence the truth, which is that the plaintiff came in and admitted on the stand that she was the one that violated due process. She was the one that committed a felony against the Fair Housing Act at the federal level and the Iowa Uniform Residential Landlord Tenant Act. And that's what they're trying to hide and cover up. And so this other order says dismissed at defendant's cost. And that too is a constitutional violation. Again, just like I pointed out here earlier, when Cooley dismissed this on the 2nd of February, so it was actually 22 days because this was just filed this morning. So they gave it 22 days after the dismissal. But see, this was dismissed without prejudice by Cooley, and he had no jurisdiction to do so. Okay. So the stage right here is where I entered the supplemental memorandum from defendants. And then I filed an enlarged findings and request judicial determination on the merits and production of documents. Abbott Andrew denied that, but he had no jurisdiction to deny it, just like Cooley didn't. This should have been going to Heather Feldkamp. She's the one that presided over the hearing. She's the one that has the jurisdiction to hand down the merits of the case, because she's the one that was presiding on the bench when that woman testified that she failed due process by sending a 7-day notice to cure under the Iowa Uniform Residential Landlord Tenant Act, which is a strict statutory requirement for her to do so as a property manager. And that's why we check with the licensing bureau to find out if she's properly licensed. We're still waiting to hear back on that. But like I said, Stephanie Rotenberg entered in a dismissed at defendant's cost. Well, let's take a look at the problem with that. This is a very recent case in Iowa. And this is why, God damn it, I got to show you the trial record. This is what I've been talking about going over when I talk about Cooley dismissing without prejudice. He had no jurisdiction to do so upon the plaintiff's voluntary request to dismiss, because it was already taken under advisement on the 26th. Where is the court docket for what happened on the 26th that the judge took it under advisement? It's missing. There's nothing there. Okay. They're trying to hide it. Okay. This is the dismissal. This was the 23rd, 3 days prior to the hearing. This is the 29th, where I entered the supplemental memorandum from the defendants. And there is no hearing in there. The hearing should have been posted, taken under advisement. Comments taken under advisement. 1/26/2026. There's nothing in there. So let's take a look at what Iowa decided January 9th. Greetings, Ruck. And we got Rebel Studio. We'll pull that up. Remind me to look at it here when I get done with these two videos. They're both going to say the same thing. This is Local 5 ABC.
Yesterday, the Iowa Supreme Court ruled that agreements to pay for defense costs and dismiss cases violate state law. This all stems from a case involving Ronald Bagley. He had 4 criminal cases against him, but worked out a deal to plead guilty to 2 cases, and the court dismissed the other 2. Advocates say the justice's ruling is progress.
We're hopeful that this decision will prevent these kinds of agreements from being made in the future, since they tie people down to what is often a lifetime of unpayable debt with heavy consequences, which I know personally from representing indigent folks in Iowa for almost 2 decades.
The ACLU said before the ruling, if the court sides with P.I.G.S.C.U.N.T.S, the plea deal should stand, but the court ruled to send the entire plea bargain back to district court, including the conviction and its sentence.
One of my favorite buggiest.
Yeah, and that's because they're trying to get him on all 4 charges instead. So
The Iowa
the point here is that once a case is dismissed, they cannot charge the defendant for costs, particularly if the defendant is indigent. So again, it's a statutory bar now. So again, and this is a recent ruling, and I don't really care because they're the ones that are supposed to know. I know, and now they're gonna know. Because again, Stephanie Rattenberg stepped in without jurisdiction. Okay, trying to hide this shit. Let's take a look at this one.
Supreme Court rules that the state can't charge low-income defendants whose court cases were dismissed. Justices ruled in favor of a man who had to pay court fees for cases that were dismissed against him. In 2024, Ronald Pagliai faced 4 charges. He pled guilty to 2 of them. The other 2 were dropped, but Pagliai had to pay court costs in all 4 cases. The case.
And that's a problem. It's just like debtor's prison. If the case is dismissed, then the costs are automatically, according to this, the letter of the law, to the plaintiff. They're subjected to the plaintiff, not the defendant.
Focuses on defendants that have court-appointed defense attorneys and are already low income.
We are all entitled to the presumption of innocence until proven guilty under the Constitution. And when charges are dismissed, there is no conviction, and there should also be no debt.
Absolutely. And that's what we're fighting in this case. Because in this case, there should be a conviction, but it should be held against the plaintiff. And that's what they're dodging. That's a criminal conviction. That's a felony. And we're going to talk about those.
A person who is legally innocent of a criminal charge shouldn't face a criminal penalty for it, plain and simple.
An attorney in the case says thousands of Iowans owe court costs totaling in the millions. In the 5 years of data gathered, the collection rate of those funds is around 2%.
Amazing. Amazing. Let's take a look at this one. Oh, yeah. Use of public office for private gain. An employee may not use their public office for their own private gain, for the endorsement of any product, service, or enterprise, except as otherwise permitted by this part or applicable law or regulation, or for the private gain of friends, relatives, or persons with whom employee is affiliated in a non-governmental capacity, including nonprofit organizations of which the employee is an officer or member, and persons with whom the employee has or seeks employment or business relations. The specific prohibitions set forth in paragraphs A through D of this section apply to general standard, but are not intended to be exclusive or to limit the application of this section. In other words, it's to be construed very broadly. Did everybody go read? B, appearance of governmental sanction. Except as otherwise provided in this part, employees may not use or permit the use of their government position or title or any authority associated with their public office in a manner that could reasonably be construed to imply that their agency or the government sanctions or endorses their personal activities or those of others. See, it's eroding the public confidence when these people in these public offices consistently violate due process. Consistently, they have violated due process in this. So let's change up here. Because they are certainly keeping me busy, folks. Going down tomorrow to finally send out the judicial notice to the Judicial Qualification Commission, and of course a certified green return receipt for that, as well as a certified green return receipt for the Blackhawk County District Court for the chambers of Chief Judge Kellyanne LaCar in addressing the 3-card money that's going on now, and have her hand down the official judicial ruling that it be handed back to Heather Feldkamp for that final judgment. And then, of course, the District Court Administrative Office, Lena Height's going to get a copy of that as well as the filing. Now we've got more filings. So let's look at it. Affidavit of federal and state irregularities. I, Keith Little, hereby swear that Magistrate Cooley allowed a dismissal in violation of Rule 1.943 to suppress a confession of retaliation. This is a procedural due process violation, which can be construed as constructive tampering in violation of the spirit of 18 U.S.C. 1512 and 1519. Again, I urge you folks to read these. Magistrate Abbott has refused to review said confession, creating a structural error in these proceedings, which is an extension of procedural due process violation and is itself another procedural due process violation. So it's allowing the extension of the procedural due process violation by Cooley, refusing to review it. He's again creating another due process violation himself, because it shouldn't go to Abbott. He has no jurisdiction as well, just like Cooley has no jurisdiction to do the review. That's supposed to be Heather Feldkamp. Abbott ignored a mandatory statutory presumption, retaliation, and is unfit under the Iowa Code of Judicial Conduct. This goes to his competence. Rule 51.2.2, impartiality and fairness. Abbott is effectively withholding a record in violation of the spirit of 18 U.S.C. 1512 and 1519. If the clerk is coding these entries as voluntary dismissals, despite knowing a trial occurred, they are making a false entry in official record, which is also a procedural due process violation, 18 U.S.C. 1519. The clerk has a ministerial duty to ensure the docket reflects the truth of the proceedings, not some judge's wanton desire to dismiss for no reason whatsoever. He shouldn't even be involved. Source, Iowa Code numbers, section 602.1215. This statute defines the duties of the clerk. It mandates that they manage and maintain all court records. Source, Iowa Court Rule 16307. Under the electronic docket management system, the E.D.M.S., where you file these filings rules, the clerk has a duty to ensure the electronic docket accurately reflects the filings and the status of the case. This is why I pointed out the status of the case was under advisement. Where is that record? Where is that filing? Where is the index that shows Heather Feldkamp took case number SCSC 200-826 under advisement? This is at minimum a misprision of felony under 18 U.S.C. 4. Source, Antoine versus Byers and Anderson, Inc., U.S. Supreme Court. The court held that tasks that are administrative or ministerial like recording a docket or preparing a transcript, are not protected by the absolute immunity judges enjoy. Chief Judge Kellyanne LaCar, as the administrative head, once she is put on notice via our certified mail of the shuffle, her failure to act becomes misprision of felony. Again, at a minimum. They've all been given notice that a felony has occurred, not just by myself and my supplemental memorandum of law and motions to review the record and motions to renew the motion. They all now have knowledge that a felony has occurred because the plaintiff admitted it. She's the one that got on that stand and admitted that she violated the Uniform Landlord or Residential Landlord and Tenant Act, which is the Federal Housing Act. She has the supervisory authority to halt the shuffle and return the case to a single trier of fact for a final judgment. That being Heather Feldkamp. Chief Judge Kellyanne LaCar has the supervisory authority to fix the record because it has an error in it. Somebody took jurisdiction when they didn't have jurisdiction to do so. And they had a strict statutory bar from doing so, or excuse me, strict civil rules bar from doing so, as well as the fact that they had a strict statutory duty of presumption of retaliation and didn't review the record to find that. Again, why it was supposed to go to Heather Feldkamp. Source, Iowa Court Rule 22.5. This is the general supervision rule. It states, chief judges shall, it's the same thing as must, exercise continuing administrative supervision within their respective districts over all district courts, judges, magistrates, officials, and employees. Source, Iowa Court Rule 2210, subsection 4. This rule specifically requires the chief judge to review cases taken under advisement. Since our case was under advisement with Magistrate Feldkamp before the shuffle, the chief judge has a direct duty to investigate why this case was diverted. Instead of handing down a judgment that day, which is the normal course of business in those eviction courts, there lies a presumption of retaliation that must be investigated. This is why they now are supposed to technically, in my opinion, set a hearing to let the plaintiff come before them and present evidence that it was not retaliation, which again, like I've stated before, I would even be willing to admit that it wasn't retaliation because they admitted not knowing they had a strict statutory duty. Still a due process violation, however. Source, Iowa Code 602.1211. This reinforces that the chief judge shall supervise the performance. This is why we go after their oath. Performance of all administrative and judicial business of the district. If Chief Judge Kellyanne LaCar continues to deny our motion for review despite being informed of the magistrate's shuffle, she and the magistrates may be in violation of Iowa Code of Judicial Conduct, Chapter 51, and 18 U.S.C. 4, 1512, and 1519. Rule 51.2.2, impartiality and fairness that I mentioned before. A judge must apply the law fairly and impartially. Ignoring a confession of retaliation to favor a landlord is a violation. Rule 51.2.5, competence, diligence, and cooperation. Judges must perform judicial duties competently and diligently. Allowing a case to be shuffled away from the evidence is a failure of diligence. Rule 51.2.12, supervisory duties. This is the hammer for chief judge. It states a judge with supervisory authority, blah, 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 shall take reasonable measures to ensure that other judges properly discharge their judicial responsibilities. This means she has a duty to take note that these other judges had no authority to dismiss or deny any motions. It was under advisement. She had a duty to investigate why with Heather Feldkamp. No one else. Rule 51 1.1, compliance with the law. This is the baseline. A judge must comply with the law, including the Fair Housing Act at 42 U.S.C. 3617 that I mentioned in yesterday's video, and Iowa Code 5628.36, which I've mentioned numerous times. This is the felony that the plaintiff admitted to under oath in open court and triggered the statutory duty to hand down a presumption of retaliation if the plaintiff cannot show otherwise. And like I said, I would even be willing to agree with the plaintiff that it was not retaliation, but pure ignorance. But we all know that ignorance of the law is no excuse. She's been doing this for 8 years and should have long ago known, before she even started in business, the requirements. Under Iowa Court Rule 22.5 and Iowa Code 602.1211, the chief judge holds the ultimate administrative responsibility for the integrity of the record in this district. To deny review of a confessed violation of the Fair Housing Act and Civil Rights Act while the record is being administratively shuffled by magistrates Cooley and Abbott and now Rattenborg, contains several violations and is a constructive obstruction of the defendant's right to a remedy under Article 1, Section 1 of the Constitution of Iowa Constitution. This is not a challenge to a judge's discretionary ruling. It is a challenge to the failure to perform a ministerial act required by statute. The judge has no discretion to ignore a mandatory presumption of retaliation or to allow a dismissal that is expressly barred by the rules of civil procedure. The trial had concluded, and there was conclusive evidence she admitted to these violations and was under advisement with Magistrate Feldkamp. Magistrate Cooley lacked the jurisdiction to swoop in and grant a voluntary dismissal. Magistrate Cooley acted in the clear absence of jurisdiction by entering an order in the case that was already under advisement by another member of the court for the purpose of facilitating an illegal dismissal under Rule 1.943. With this information provided in a supplemental memorandum of law, Magistrate Abbott dismissed it and all subsequent motions regardless of his duty of the same. So on February 2nd, when Cooley, who lacked the jurisdiction, dismissed it, it was void. But they are playing that as if though it's still valid that they dismissed it. But that's their dependence on that 20-day time frame. So on the 22nd day, now we have another judge, a district associate judge, who is above the magistrates, that now comes in with the dismissal at defendant's cost, which is summarily supposed to be a final judgment, entirely closing the case. So when she did that, it confirmed this very thing right here. All actions from the start of these matters in a noise complaint have been procedural due process violations to this day and continues to harm the defendants adversely. It has caused a significant change in lifestyle and finances that impact our daily lives and means of not just existence, but survival. And now, this 24th day of February 2026, despite my motions and conclusive evidence, the plaintiff already judicially admitted to statutory breaches. Judge Stephanie Rottenborg, a district associate judge, and her entry into the case now confirms the structural obstruction. By having a district associate judge sign a final dismissal, the court is trying to clean the procedural errors made by the magistrates. They want a higher level signature to make the illegal dismissal under Rule 1.943 1943 looked legitimate. If Rattenberg signed this without reviewing the January 26th confession, she has participated in the due process violation as well, just like Cooley and just like Abbott. If you failed to read them, you were given notice. You had no reason to not understand this. She has rendered a judgment on the cost without addressing the merits, the confession, that were already under advisement. This is a jurisdictional gap. District Associate Judge has no jurisdiction to dismiss a defendant's costs. She is now the signing authority on the obstruction. By assessing costs to the defendants, she has created a financial barrier to our appeal. This order confirms that the court is treating the case as a summary matter, just a dismissal, rather than a substantive judgment, which is the confession. It was a judicial confession. When it comes to the 14th Amendment, Section 1, you can read through it and figure that out. Tells you all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the states, nor shall they any state deprive any person of life, liberty, or property without due process of law. So our next one, let me take a look and see if anybody's got anything going here. Matt's here. We got Caucasian Sasquatch. And here I am. The government doesn't care and never holds itself accountable. Absolutely. That's why we have to. That's why I'm doing all this research. And that's why I explain to people two things I want to make note. Do not believe me. Do not believe the neighbor. Do not believe the government. For crying out loud, do not believe your mother. Do your research so you know. In that, keep doing your research. If it weren't for me continuing my research, I wouldn't have found this January 6th case, very recent case right here in Iowa for this exact purpose. They already know or should know by case law that they now have a strict statutory duty not to charge the tax or charge the cost to the defendant. When a case is dismissed, they are barred from taxing the cost to the defendant. That's strictly in the rules of civil procedure already to be taxed to the plaintiff. If the plaintiff comes in and dismisses, it's taxed to the plaintiff. They're doing a little switcheroo and charging it to the defendant who filed in forma pauperis. It's fucking utterly ridiculous. So let's get back to it. This is a motion to vacate order assessing costs to defendant. Comes now the defendant pro se and moves this court to vacate the order entered by Judge Stephanie Rottenberg on February 24, 26, which assessed court costs to the defendant following the plaintiff's voluntary dismissal. In support thereof, defendant states lack of statutory authority. Iowa Code 625.1. Costs shall be recovered by the successful against the losing party. A plaintiff who voluntarily dismisses their action is not a successful party. Furthermore, Iowa Code 625.11 explicitly states, when a plaintiff dismisses the action, blah, 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 judgment for costs may be rendered against such plaintiff. There is no provision in Iowa Code that allows the court to saddle a defendant with costs when a plaintiff chooses to abandon their claim to avoid a judgment on the merits. Violation of mandatory duty, Rule 1.943. As previously briefed, the plaintiff was procedurally barred from dismissing this case under Rule 1943 because the trial had already concluded and was under advisement. assessing cost to the defendant in the case where the plaintiff admitted to retaliatory conduct, Iowa Code 5628.36, and notice violations, Iowa 5628.27, is an abuse of discretion and clear absence of all jurisdiction. Due process in the P.I.G.S.C.U.N.T.S precedent. This is the one just now, January 9th. In the recent landmark decision, State versus P.I.G.S.C.U.N.T, Iowa, January 9th, 2026, the Iowa Supreme Court ruled that the judiciary does not have the authority to assess costs in dismissed cases without specific statutory authorization. Assessing costs to the defendant, here is a criminal style penalty in a civil matter. It forces the victim of a confessed constructive eviction to pay for the privilege of being sued. This is a violation of the Right to Remedy Act, or Right to Remedy, Iowa Article 1, Section 1, and constitutes a financial barrier to the appellate record. Conclusion, the order assessing costs to the defendant is a legal nullity and must be vacated. Costs should be taxed to the plaintiff as a party who initiated the action and subsequently sought its dismissal to avoid a verdict. Any questions or anything, feel free to drop a comment in the chat. On to the addendum to the judicial complaint and notice to Chief Judge. So we're going to add this to our filings. Oh, this is the one that's going to go to the go with this motion to vacate order assessing costs to the defendant. This is going to go with that. It's an addendum to the judicial complaint and notice to the Chief Judge. So we're going to file both of these. So when I go down to court tomorrow and file this judicial complaint and notice to the Chief Judge, this is going to be an addendum to that. And I'm also going to file the motion to vacate. I hope that makes sense to everybody. So this is going to be added to the file as an addendum. The cost penalty as a constitutional injury. On February 24, 2026, Judge Stephanie Rottenborg entered an order dismissing the case but assessing court costs to the defendant. This act is a direct violation of the Iowa Supreme Court's ruling in State versus P.I.G.S.C.U.N.T, Iowa, January 9, 2026. The violation of the P.I.G.S.C.U.N.T court held that the judiciary lacks the statutory authority to saddle defendants with court costs in cases that have been dismissed. The bad faith, assessing costs to a defendant who has already provided evidence of FHA retaliation and a confessed 7-day notice failure, acts as a bounty for the plaintiff's illegal conduct. It is a financial punishment for a party who is already winning the case on the merits. Chief Judge's supervisory failure. Chief Judge C.O.W.A.R.D.S has been placed on notice regarding the magistrate shuffle involving Cooley and Abbott. The subsequent participation of Judge Rottenborg in this shuffle to finalize an illegal cost assessment demonstrates a total breakdown of administrative oversight. Ministerial breach under Iowa Code 602.1211. The Chief Judge must supervise all judicial officers. Allowing Judge Rottenborg to sign an order that contradicts Iowa Code 624.15, which mandates costs be attached against the plaintiff upon dismissal, is a failure to perform a non-discretionary ministerial duty. Let's not forget the fact that she also has the statutory duty to investigate all cases that are diverted. Evidence of clear absence of jurisdiction. Judge Rattenberg's order was entered while the case was technically still under advisement following the January 26th trial. Because Rule 1.943 barred a voluntary dismissal at that stage, any judge, including a district associate judge who facilitates that dismissal, is acting in a clear absence of all jurisdiction. This specifically bypasses judicial immunity, as the court had no legal authority to accept a dismissal once the trial had concluded. Specific rules Judge Rattenberg and the chief judge are violating is Iowa Code 625.1. This statute is mandatory. It states that when the plaintiff dismisses, judgment of cost may be rendered against such plaintiff. There is no statutory path to tax them to a defendant. None. None whatsoever. Rule 51, 2.12, the chief judge is violating this by allowing her subordinates to shuffle the case until they find a judge willing to sign an illegal cost order, an illegal dismissal. By coding this as a dismissal at defendant's cost, the court is creating a false record of the proceedings outcome to impede the defendant's appellate rights. And just by dismissal at defendant's cost, I want everybody to pay attention here. It's on the public record. It was dismissed at defendant's cost by Stephanie Rattenberg, despite state law, Iowa State versus P.I.G.S.C.U.N.T.S. Okay. So she admitted in, on, and for a public record with her own signature, dismissing and finalizing the case at cost of defendant. Both of those are constitutional due process violations. Again, she has no authority to do so. If anybody had the authority, it would be Kellyanne LaCar, the chief judge. But even then would be a false determination of dismissal because, again, the conclusive evidence on the record is already beyond reproof. You cannot deny it. The woman admitted to a felony against the Iowa Uniform Residential Landlord Tenant Act. I am demanding a formal audit of why Judge Rattenberg was permitted to assess costs against defendant in a dismissed case in direct defiance of P.I.G.S.C.U.N.T.S 2026 ruling and Iowa Code 625.11. This isn't a judicial decision. It is an administrative illegal act designed to finalize the constructive ouster of a disabled tenant. Oh, I'm having a brain fart. Let's see here. This constructive ouster by the very magistrate signing on for the original voluntary dismissal, Judge Cooley, and subsequent denied motions, Judge Abbott, shows a pattern of practice worthy of severe reprisal and liabilities, as well as removal from office or re-education at minimum. It creates yet another constitutional issue. Every last time these guys operate outside of their jurisdiction, it is a constitutional issue. In yes, I did that. I've done a lot of motions here, and they're just denying everything. And despite the fact that they're all violating that rule 1.943, it's supposed to go back to Heather Feldkamp and no one else. And in that, the chief judge is supposed to investigate it, and that's who Heather Feldkamp is subject to under advisement. She's supposed to take it under advisement to the chief judge. That's the failure. That's why we're filing these motions tomorrow and directing the attention directly to Chief Judge Chambers in their chambers. Certified mail, the business manager, Lena Height, and of course, filing it into the electronic records. All three services. Let's take a look at one last thing, which is the supplemental notice of judicial misconduct. This is going to the Iowa Judicial Qualifications Commission again. We've got one already set up and ready to send out. We're going to have to send this one out as a supplemental notice to tack on for Stephanie Rattenborg and her recent no jurisdiction dismissal. This supplement is filed to alert the commission to the continued three-card Monty shuffle in Blackhawk County case number SCSC-200-826. On February 24, 2026, Judge Stephanie Rattenberg entered the proceedings to finalize the voluntary dismissal previously facilitated by Magistrate Cooley. In doing so, she exceeded her statutory authority and engaged in conduct that brings the judicial office into dispute. Violation of Iowa Code 625.11, Judge Rattenberg assessed court costs to the defendant. Iowa law explicitly states that when a plaintiff dismisses an action, costs must be rendered against the plaintiff. There is no statutory authority to tax costs to the defendant in a dismissed case. Defiance of Supreme Court mandate, State versus Pagley, January 9, 2026. The Iowa Supreme Court recently ruled that the judiciary lacks jurisdiction to assess costs against defendants in dismissed cases. Judge Rattenberg's order is a direct defiance of this clear and certain law. Facilitation of structural obstruction. By signing this order, Judge Rattenberg acted as the closer for the administrative shuffle. She finalized the dismissal that was barred by Rule 1.943 as the trial had already concluded, thereby insulating the plaintiff from the legal consequences of their recorded confession. Breach of judicial canons. Rule 551.1 compliance with the law, as we spoke of earlier. 51.2.2 impartiality and fairness. 51.2.5 competence and diligence. Request for investigation. I request that the commission investigate the coordinated effort between the clerk, the magistrates, and now Judge Rattenberg to use voluntary dismissals as a tool to suppress records of Fair Housing Act violations and to financially penalize victims of retaliation. I think it's pretty clear. They have no substance in law that says they're allowed to do this stuff. And yet here they are. They keep pushing forward and trying to tax somebody that's a defendant who has already given an affidavit of indigency, and they denied their motion for informal pauperis. This is all clear and present evidence that they're trying to cover and silence something that should be known. You have a right to know this. The First Amendment is great in me being able to speak about it, but you people out there exponentially have a right to know. So when they try to hide records like this, it's my duty, because you have a right to know that is greater than my freedom of expression. It's my duty to point it out and show you how it's working, show you how they're wrong, show you where their due process is falling apart, and show how each and every last one of them is in fact involved in it. Each one of these people is supposed to know their job, let alone the law of that job. And this is what I'm pointing out. The lady that runs the property management, she doesn't know the law. My dad was a real estate assessor for the federal government and then for the local county government. And I guarantee you, he never read the Real Estate Act. I guarantee you, Real Estate Investment Act. I guarantee you, he never read that stuff. My mom worked for Social Security Administration for like 29 years. I guarantee you, she never read the Social Security Act. These people don't know the laws that they're subject to because they just don't give a fuck. They have a court system that works for them because that's what brings in the buck. It's all about the money. Well, I don't give one fuck about the money. Not for myself. So I'm able to live humbly and live without money. And I at the same time, I urge you to please help out. We are financially strapped and are having a very hard time moving forward with these filings if we can't afford it. And they're cutting off every avenue. So I at least get to get this stuff filed tomorrow. We'll see how that works. In the meantime, oh yeah. Just another issue I got to deal with. My wife's dementia and her doctors. Trying to get them to put forth whatever information they can to help us out. That's been fun. Fun fact, if you don't make a motion to reconsideration, it is presumed you waived right to challenge the ruling by not making the record clear. No, no, you don't understand, tribe. It was under advisement, and there is no way they could have handed down a dismissal for the plaintiff because she got on the stand and testified to a felony. They have to recognize the felony. Misprision of felony, 18 U.S.C. 4. He who cognizes a felony and does not report it is subject to 3 years imprisonment. That's why they have the strict statutory duty to presume retaliation in Iowa. And there's case law on that I pulled up as well. They know all of this information. How do I know? Because I put it in all my documents. And it was a reconsideration, review, de novo, same thing. You want to call it reconsideration? I call it review de novo. And that's what I'm doing. I'm making the record very clear. Stephanie Rottenborg made it very clear today. She violated Iowa law. January 9th, state versus Paglia says clearly you can't charge costs to the defendant. There's no law that allows for that. And so she went beyond her statutory allowance and issued a dismissal, supposedly finalizing a case that came upon a voluntary dismissal from the plaintiff who was barred from entering a dismissal at that point. So it still is sitting there for the merits. And all we're doing is forcing that judge to bring forth the merits. Otherwise, all these constitutional violations of due process go in effect for all of them. They're all violating due process. But the ones that have a duty, according to the law, is Heather Feldkamp and Kellyanne LaCar. The magistrate who presided over the hearing and heard the confession on record of a felony by the plaintiff, barring the plaintiff from being awarded the suit. And yet they somehow awarded a dismissal, which states there's no winner, when there was substantive process, substantive conclusive evidence. They're not allowed to do that. That's a violation of federal law. And now they're trying to hide that record. Well, I got the transcripts coming. So if I have to take it to a higher court, I bring the transcripts out. So we'll see how that works. Because I don't think too many of these guys are going to want to go to federal court and be found for constitutional violations of due process. Every last one of them. The property manager, Judge Cooley, who took the case and then handed it off to Heather Feldkamp to preside over the hearing, and then granted a dismissal after Lubin denied the court stenographer. Yeah, he denied a court recorder. Said there weren't any. 3 days prior to the hearing. So yeah, all kinds of nice things. Everything we've applied for has been denied. Everything the plaintiff wanted, they were granted, despite the fact that they were barred from doing so. Technically, they were barred from even filing a suit. They filed the suit. That's what brought on the retaliation. In that filing the suit, they admitted on the stand that they're the ones that violated their strict statutory duty to give a notice. Oops. Now we have multiple judges all trying to hide it through a shuffle, 3-card Monte shuffle. We've got 6 judges involved now. Chief Judge Kellyanne LaCar, District Associate Judge Stephanie Rottenberg, Judge Cooley, who entered and validated the case, Lubin, who denied the court reporting, I guess maybe it's 5, Abbott, who denied all my motions. So yeah, fun times. We'll see how it goes. Just wanted to give everybody an update on what's going on because it's getting fucking ridiculous. And in the meantime, I hope everybody has a wonderful day. Hit the like, share, and subscribe. Hold on. Trying to get this set up here. And enjoy it. Don't let them tie your tongues. Learn how to speak out. Other people have a right to know. And it's not about your victimhood. It's about pointing out their errors. Because that's what makes people victims. I'm not a victim. I'm a winner. I'm going to stand. I'm the one that has standing. She already admitted on the stand that she didn't have standing, that she's the one that violated the law. So hit that like, share, and subscribe. Hopefully you can hit that PayPal link and help me out a little bit here. Things are getting tight. And in the meantime, I love you, but I don't give a rat's ass whether you love me back.